correct?
That is correct.
P4. And did that mediation ever happen?
No.
Okay, and why not?
Kimberly, my daughter, did not show up, or she had an excuse or something was going wrong.
Okay, so did you ever attend that mediation?
No.
Okay. Your Honor, I'd like to ask to enter P4 as an exhibit.
Any objection, Mr. and Ms. Harrington, to P4?
No.
Okay.
P4 is admitted.
Ms. Leckert, I'd like to draw your attention to P5, which are email exchanges between Danny Hoke and Barker Law Firm confirming mediation for the second time on October 29th, 2020. Is that correct?
That is correct.
Did that mediation ever happen?
No, ma'am.
Why not?
She didn't show up.
Okay. Your Honor, I'd like to ask that P5 be entered into evidence.
Any objection to P5?
What was that? What was P5 again? I'm sorry.
It's the email exchanges between Danny Hope and respondents.
So it's the one that I had messaged him?
It is.
Yeah, that's fine. No objection. No
Okay.
objection.
All right, P5 is admitted.
Ms. Leckert, I'd like to draw your attention to the letter from Danny Hope confirming, well, that was P6. Excuse me, P6 is the letter from Danny Hope confirming the first mediation on 10/29. Is that correct?
That's correct.
Okay, Your Honor, I'd like the letter from Danny Hope to the parties confirming the mediation on 10/29 to be entered into evidence.
Any objections, Ms. Harrington or Mr. Harrington?
No, Your Honor.
P6 is admitted.
Ms. Leckert, I'd like to draw your attention to P7, email exchanges between Barker Law Firm and respondent confirming this second mediation on March the 1st, 2021. Did that mediation happen?
No, ma'am.
Why not?
She said that she couldn't make it. She didn't
show up that day?
No.
Okay. Your Honor, I'd like to enter P7 into evidence as of the mediation, the confirmation of email exchanges between Barker Law Firm and respondent confirming the second mediation on March the 1st, 2021.
Any objections, Ms. Harrington or Mr. Harrington?
No, Your Honor.
P7 is admitted.
And Your Honor, Ms. Leckert, I'd like to draw your attention to P8, which is the letter from Danny Hope concerning the mediation on March 1, 2021.
That's correct.
And that's the letter where the mediator, Danny Hope, who was appointed by the judge, is confirming the second mediation. Do you have any, did that, and that's also, that mediation did not happen?
No.
Okay. Your Honor, I'd like to enter in P8 as exhibit P8 into evidence.
Mr. Harrington, Mrs. Harrington, any objections to P8?
No, Your Honor.
P8's admitted.
Ms. Harrington, this is a real brief background. It's been a long struggle, has it not, with these children trying to get this case resolved?
Yes, ma'am.
Miss Leckert. Did I say Miss Harrington? I'm sorry, Miss Leckert. I was calling you. I apologize. When were the children placed with you?
February of 2019.
So they've been with you over 2 years here in Fort Bend County. Is that correct?
Yes, ma'am. That's correct.
When were the children taken by CPS away from their parents?
November the 10th of 2017.
And how did you spend a long time going to tell me about the year in between 2017 and the year that they were placed with you in 2019? Was there a
Miss-
CPS case in Mississippi?
Yes, I spent
did
time
you-
going,
And did you spend a lot of time going to Mississippi?
yes, because I was concerned for the kids. And actually, my daughter,
And so on November 10th, when they were taken by CPS in 2017, were they placed to several family members or just you?
yes, they were
No
placed,
one. Okay.
yes.
And then you spent over a year driving to Mississippi continuously to try to resolve this. Is that
Yes.
correct?
Yes,
And now here we are in April of 2021, and we still don't have a complete resolution. Is that correct?
Yes. That's correct.
And you've
It will
had
be-
these children placed by CPS with you for over 2 years in your home.
That's correct.
And would you like to request, and we've tried over 3 times to get the Harringtons to go to mediation. Is that accurate?
That's correct.
With a very good mediator, Danny Hogue. And we have not been able to have a mediation yet. Is that correct?
That is correct.
Through no fault of your own.
No fault of my own.
Okay, and are you wanting to ask the judge today that this inaction be stopped and this petitioner requests the court to waive the mediation requirement and to set this case for final trial? Is that what you want the judge to do?
Yes. Yes, that's
Okay.
what I want.
Thank you, Judge. I pass this witness.
Ms. Harrington or Mr. Harrington, if you have any questions of this witness, you may ask questions. It's not your time yet to tell me what you want to tell me. I'm going to let you do that in just a second. But if you have any questions of this witness, you may ask questions at this time. Ms. Harrington, do you have any questions of the witness?
No, Your Honor.
Mr. Harrington, do you have any questions of this witness?
No, sir.
All right. Ms. Barker, any other witnesses that you'd like to call on your motion to waive mediation?
No, Your Honor, that's all I have today. I'll rest. This has been going on a long time. We need these
And I
children.
I heard the testimony of that. And I recall talking to the judge in Mississippi on this case on a UCC JEA conference. So I'm familiar with, and I remember compelling mediation. So I'm familiar with the facts. Ms. Harrington, anything that you would like to add about the court's decision? The only thing we're deciding today, we're not getting into the facts of the case.
Yes, sir, I
The
understand.
only thing we're deciding today is whether or not I should send y'all to mediation or if I should just set this case for a final trial. That's the only issue that I have before me today. So that's the only thing I'm going to allow you to talk about.
That's fine.
'Cause there's a day coming where we'll talk about everything, but today is not that day.
Okay.
So Ms. Harrington, anything you would like to add on the motion to waive mediation?
The first mediation, I believe it was rescheduled due to not because I didn't show up, but because Mr. Danny had sent an email stating that Ms. Barker's office had to change or something. I'm not sure. I don't have the email in front of me, so. But the second mediation, the reason why I couldn't set that is because I had court in Mississippi for, a traffic related ticket. And so I had to attend to that. So, and I let Mr. Danny know. And then the last time I've had to move in with my grandmother. She raised me, so I'm basically taking care of her now. She's not able to no longer take care of herself. And so she was in the hospital for the mediation that was the March the 1st. And I had let Miss Lickert know that. And we had already had a conversation. In fact, we had already talked about me and Miss Lickert had come to an agreement, and I had let Miss Barker's office know that, I talked to my mom about what I wanted, and basically I just really she hasn't let me see my kids now in a couple of years. And I just want to be able to see them. And so I'm ready to come to some sort of agreement so that I can see them. And it's hard not to be emotional about it because it's my children. Because this has been all different for us. So it's not like I didn't try. And me and my mother have come to I thought we had come to an agreement. So, you know, I didn't think that, you know, we needed to do mediation because we came to an agreement on the phone together, you know, without, there was no lawyers and it was no court stuff. It was just me and her talking like a mom and a daughter, you know? So, you know, if this is going to push it to where I get to see some sort of visitation with my children, then I'm for it.
Thank you, Ms. Harrington. Ms. Parker, any questions of this witness?
No, Your Honor. I think the facts speak for themselves.
Mr. Harrington, any questions of this witness?
Oh, no.
All right, Mr. Harrington, anything you'd like to add on this motion to waive mediation? Or do you just echo Ms. Harrington's statements? Did you say no? I'm sorry, I didn't hear you.
I said no.
Okay.
No.
All right, any other witnesses, Ms. Harrington or Mr. Harrington, that y'all would like to call as it relates to the motion to waive mediation?
No, sir.
Thank you. Ms. Barker, anything further from your side?
No, Your Honor.
All right, the court's heard the arguments and reviewed the paperwork, and I agree with both sides that this case needs to be completed and there needs to be a day where this case gets resolved. Mr. and Ms. Harrington, my hope was that y'all could work that out without having to come to me to do it. And there's still a chance for that. You mentioned that y'all had negotiated directly together, and y'all can continue to do that. But it's important for me that this case gets finished because it will provide stability for everybody involved in the case.
Yes, sir.
And so I am going to grant the motion to waive mediation at this time. For whatever reason, we're not able to get the mediation done. And I don't want this case just lingering out there and everybody not knowing what their rights are or what their responsibilities are. So I will make a docket entry that I'm waiving mediation. Ms. Barker, you'll need to set the trial date out about 60 days, just so we need to give the Harringtons at least 45 days notice. So if you want to get with the coordinator and just get a date that's about, at least 60 days out, then she can set you for final trial, and we'll come back and we'll deal with those issues, Mr. and Ms. Harrington, about possession and access and all those other things when we come in for the final trial. Make sure you have all your pleadings, both sides have all their pleadings in at least a week before the final trial, and then do like you did today. Any exhibits that you have, make sure you get those to the court reporter at least 24 hours before the final trial date, so that we don't have any more delays in the case, because it's my intent that whatever date the court selects, we're actually going to have a final trial that day and we're going to finish this case. It's very hard to get me to reset stuff once it's set, because I like to get things done.
Yes.
Okay. So thank you all very much for appearing this morning, and the motion to waive mediation is granted. Ms. Barker, let me see, did you file order on that?
Oh, I'm not sure, Judge, but if I didn't, I'll file it immediately. I believe I did, but if I didn't,
Let me look, because I may give you an entry date if we don't have it. Let me look.
Your Honor, Mr. Danny filed something on the consolidated case. It was the mediator's report. It's not on the.
Yeah, I saw that.
Okay.
I just see the motion to waive mediation. I don't see an order. So Ms. Parker, why don't we do an order? Just we'll set it for entry for April the 9th. That's next Friday.
okay, Your Honor.
And in that order. And Mr. and Ms. Harrington, I need to, and why don't we go ahead and do that record here? If you will give Ms. Barker your best way to get contacted by her. So if you have an email address, she needs to send you this order today that I made that says y'all don't have to mediate.
Okay.
And then you can sign that and get it back to Ms. Barker, and then nobody needs to appear on April the 9th.
Okay.
So just give her your email address so that she knows where to send this.
I receive all of her emails. I received all the. It's the same one that it's been being I got all the stuff yesterday, the exhibits and everything I'm just gonna file.
Mr. Harrington, are you getting the emails from Ms. Barker as well?
No,
I just show him
Well,
when
do
he
you
get
have
one.
an email? I understand, but he's a party too, like y'all are both considered parties, so I need for my purposes, I need him to give an email or some way to Ms. Barker to contact him, an address or an email, so that she can send him notices of like final trial and notices like this order that we're sending. So what
Okay.
address and what email? Harrington?
Does she want me to email her his email address, or does she want me to tell her?
You can give it to me right now.
No, you
Okay.
can tell me right now.
It's the AC man 422 @gmail.com.
Okay, and Your Honor, because I had trouble communicating, usually it would be no problem to have the entry on the 9th, but I have another entry that day. Would you mind if we moved it to like the day before on the 8th or something, or the 7th, when the following
You can
week?
have, yeah, Judge Heppard likes to do them on Fridays, so we can do the following week, which is April 16th for your entry.
That'd be perfect.
And then again, you don't need to appear. If you just submit the order, I'll sign it on the 16th if it's not signed by everybody.
Oh, okay, okay. Well, then if that's the case, we could just keep it where it is. I just thought, okay, no, let's change it. Yeah, just to be sure. Okay, thank you, Judge. So now you're gonna make it on what
Okay.
day? The
The entry is going to
16th?
be April 16th at 9 a.m.
Okay, great.
And
Thank
Mr.
you
and Ms.
so much.
Harrington, Mr. and Ms. Harrington, if you get that order, you can sign it and email it back to Ms. Barker, and that way it gets signed. It doesn't mean you necessarily agree with what I did today. It just means you agree that the order states
sir.
what I ordered today. And that'll save everybody from having to come back.
Okay,
And then Ms. Barker, if you'll send them notice of the final trial date, once you get that, we'll be able
Sure.
to finish this case out. Okay?
Sure
Best
will.
of luck to all of y'all. We're going off the record. Thank you. Y'all are excused.
Thank you.
Judge.
Okay, we're going to take up saw Ms. Rob will come in and Mr. Foster. We have an entry on y'all's case, and then we'll get started with the continuation of the temporary orders hearing. And then did y'all need Ms. Rabdel or Ms. Foster? Mr. Foster, did y'all need a record on this entry?
I don't need a record, Judge.
I don't believe so.
Okay. All right, then let's go ahead and get started on the Gonzalez matter. Let me switch gears and open that file up, because I saw I think there's two competing orders that have been filed, I believe. Let me look at that case. All right, I have proposed orders that were filed on March 31st.
Yes.
And then I have proposed orders that were filed on March 26th. Is that, Mr. Foster, did you draft the ones on March 26th?
Yes, well, Your Honor, I actually filed, this was heard over a month ago. We filed a proposed order on February, I believe February 23rd. But we modified just a couple of little things on our proposed order and refiled it again, I believe yesterday. But Your Honor, at the last set, this thing's been reset 3 times. I sent the proposed order over a month ago. Opposing counsel has not let me know what she feels is wrong with our proposed order. And at the last setting, I believe you had said, let's use Mr. Foster's proposed order, send him what you don't agree with. She didn't get with me between last week and this week. And then last night at 8:30, she filed a proposed order. So Judge, I'm just asking the court to review my proposed order. I made that small change that you had suggested as far as geographic restriction, making that a little bit clearer on page 2 at the bottom. I also modified just a little bit on the page 5 under modified supervised possession to make it clearer as far as father's access. But other than that, I believe everything matches the court's rendition of what you had ordered. And like I said, Ms. Rabdale has not gotten with me in over a month to let me know what she feels is wrong with our order. And we're just asking the court to enter it.
We're gonna go off of this order that was filed by you. And I did tell y'all that I remember last week's hearing that we needed to get whatever proposed changes we had to the other side, because I didn't want to be doing this stuff with the court, because there's some proposed changes that y'all might not have any objection to. But Ms. Rabdale, we're going to go off the order then that he submitted yesterday. And I just need to know
I don't know
what
that I ever got
issues.
that, Your Honor. This new order
So
from.
you never got.
No.
Your Honor, it was e-filed. Her email address is on the e-file. I believe I can check.
That may be the case, but I haven't printed it. I can look at it. The issue, Your Honor, was this, and I don't know how to say this without sounding, I don't know, mean or something, but the order, as I said, that was drafted by Mr. Foster does not comport with the format of the Texas Family Practice Manual, and there were significant portions, as I stated previously, that were missing. So as a result, instead of tweaking it, I just redrafted it because there were so many issues, basically. So it took a while to do, and apologize for the delay. But the order that I have drafted and proposed comports with the Texas Family Practice Manual and is in compliance with the rendition, the transcript of which I have sent to Mr. Foster for his review or consideration. For one thing, the order that was drafted by Mr. Foster contains a lot of missing pieces with regard to health insurance information. There's also provision in here for the parties to communicate directly, but specifically in the rendition, the court recited a ruling, I thought, which required the parties only to communicate in case of an emergency regarding the child. Otherwise, they were only to communicate through talking parents. So, we could go through it line by line, or Mr. Foster and I could go to a breakout room and do that. But there were significant issues that I found that were problematic, so it necessitated just doing it over. And I'm sorry it took so long to do.
Your Honor, this has been reset 4 times, or this is the 4th setting. The court has told Ms. Rabdale to let me know what her issues were. I have never received one email or one call concerning this order. She just now filed her proposed order at 8:30 last night. I haven't even had time to look at her proposed order. I'm just asking the court to enter our proposed order that was filed over a month ago.
You can't. It's not in compliance with the rendition.
I've never heard that, Judge, until today.
I know. I'm looking at, give me a second to look at my docket entry. All right, so I do see in my document, your parties or parents to communicate exclusively through talking parents except in an emergency dealing with the child. So let me look at the order. I didn't see that.
If the court would look at page 6, the proposed order says, by agreement, the parties may communicate in any method other than using the Talking Parents program, but other methods of communication used by the parties shall be in addition to and not in lieu of using Talking Parents program, which is not in compliance with the court's rendition. That's one example.
So that appears, and that's on page 6.
Yes, Your Honor.
Judge, on my proposed order on page 5, it talks about parties shall communicate through Talking Parents program in regards to communicating about the child.
I don't know that counsel appreciates that there's a difference.
Hold on. The one that was filed at 821 lines 9. I need the one that was filed. Hold on, I've got the wrong order in front of me. I need the one that was filed yesterday, earlier. Yes. Give me 1 second. I'm just having trouble following the arguments because I've got the wrong temporary order. Thank you. All right, going back to the Talking Parents issue, Mr. Foster, you said it's on page 5?
Yes, on our proposed order, Judge, page 5 at the bottom, electronic communication, talks about signing up with Talking Parents program, and then it says parties shall each communicate through Talking Parents program with regard to all communication regarding the child.
However, on page 6, above temporary child support obligation, there's a paragraph that permits them to communicate directly. However, my proposed order, I say it's ordered that the parties shall each communicate by way of Talking Parents, save and except in the case of an emergency or other urgent matter, which is pretty much a quote of the rendition by this court.
Judge, I reiterate.
Just 1 second. I'm looking at just give me a second. I'm reading this order as y'all talk, so give me a second. I agree with the parties may communicate in any manner other than Talking Parents. All right, Mr. Robdell, I'm striking that last paragraph on dealing with letting them communicate in other ways other than Talking Parents. And on page 5, Mr. Foster, I have added it is ordered that Javier Gonzalez Jr., Christina Elizabeth Gonzalez shall communicate, and I added exclusively through the Talking Parents program with regard to all communications regarding the child, except in the case of an emergency or other urgent matter. So I'm leaving the emergency or other urgent matter, but otherwise they're to communicate exclusively through Talking Parents. Ms. Robdell, what was your next issue with this order?
With regard to the rights, powers, and duties, we were asking for the inclusion of language which would afford Mr. Gonzalez the right to meaningful consultation. So instead of having the rights where Ms. Gonzalez has exclusive rights, I put a reflexive paragraph, which is on page 5 and 6 of my draft, which gives Mr. Gonzalez the right to meaningful consultation with Christina Elizabeth Gonzalez prior to Christina Elizabeth Gonzalez exercising her exclusive right to consent to medical, dental, and surgical treatment of the child involving invasive procedures. That's one. And then the right to meaningful consultation with Christina Elizabeth Gonzalez prior to Christina Elizabeth Gonzalez exercising her exclusive right to consent to psychiatric psychological treatment of the child. That's another. And then the right to meaningful consultation with Christina Elizabeth Gonzalez prior to Christina Elizabeth Gonzalez exercising her exclusive right to make decisions concerning the child's education. So I would ask the court include a reflexive provision with regard to Mr. Gonzalez's right to meaningful consultation prior to the exercise of the exclusive rights on the other side. They're on page 5 and 6 of my proposed order.
I see that. Give me 1 second. Oops.
I don't know why my video is not working, by the way. I'm trying to be seen, but I don't know how to fix it. So I'm sorry about that, Judge. I'm not hiding.
When you first came on, I thought you were appearing when you first came on, so I'm not sure what happened.
Yeah, I don't know either.
Sorry, I'm making changes as I'm working as I'm sitting here, so not that. Okay, so in the order, because I did notice in my docket entry, I had education, invasive medical, and psychological and psychiatric. I had after consultation with the father, or after prior consultation with the father, mom has those exclusive rights. So I have inserted that into the temporary order on page 4. I didn't go to the extent that Ms. Robdell, you had in your proposed order, but it does add what my ruling was, and that is mom has the exclusive right, but she needs to consult with the dad before she makes those decisions. We may beef up this language in a final, but I think for purposes of temporary orders, that language is sufficient.
Okay.
All right, Ms. Robdell, what was your next issue?
There's a paragraph on page 6 where the court makes a finding per section 153.001 about the domicile restriction and the frequent contact. That standard paragraph, I had asked that it be included, but I don't know if the court would be willing.
I'm not going to do that at this time. I agree that's standard language, but we will we'll deal with that on a final order because
Okay.
I agree it's been a while getting this temporary order entered. I want to get it entered this morning. But I think the geographic restriction is sufficient for now, and we'll add that in the final order. Unless we change the final order, so that's denied.
Okay. And And with regard to the visitation,
Yes.
the possession order is, I think, clearer. My draft is on page 7 is the possession order, which specifies, for example, the court had stated that the 6 to 8 Wednesdays would be supervised by one of Javier Gonzalez's parents. And then the court had named 2 supervisors for the Saturdays and Sundays. I'm not sure if they're the same people or not, but it's reflected more accurately on page 7 of mine. I think the visitation portion of Mr. Foster's order is on page 5 and is less enforceable.
So it looks like the docket entry says that the visitation is to be supervised by one or both of father's parents. So that's who I had in there. Let me look at the order.
Frankly, I think the language that I have on page 7.
Yeah. Well, I need the grandparents' names for sure.
It protects both parties because there's no named supervisor in the draft from Mr. Foster that I see anyway on page 5. So like I say, I think the language I have is more enforceable and protects everyone.
Your Honor, I believe.
But I'm going off it. So I'm going to add the names of the grandparents in here. Do either one of y'all have their their names for me?
I believe it's Javier Gonzalez Sr. and Alicia Gonzalez. That's what the court had in its rendition.
Javier Gonzalez Sr., and what was grandmother's name?
Alicia, Alicia, I believe.
All right, that addition's been made. Ms. Robdell, your next issue with this order?
The drop off and pickup of the child language. I have the general terms and conditions for surrender and return, along with notice for inability to exercise, personal effects, written notice, etc. That's on page 7 and 8 of my draft. Mr. Foster has language that says that Javier Gonzalez Jr. is allowed to be in the vehicle. I don't know where that came from. And it consolidates everything into about 7 lines, which works out to about 2 pages if the language is going to be enforceable. Both sides require an order that's enforceable.
Okay.
Your Honor, I provided the email that you sent to both counsel back on February 11th. And in your email, you stated, as far as drop off and pickup at mother's residence, and father is allowed to be in the vehicle during the exchange. That was your statement to us.
Yeah, I recall that, and I'm fine with that language. It's just I'm not real thrilled with the last sentence, and I'm just trying to see how I want to change it.
I'm just asking that the court consider entering the order that I've drafted because it is enforceable and more complete.
Well, I agree with that, but it wasn't filed until 8:30 last night, and this is the 4th entry, and I'm entering an order today. So I'm going to go off the draft that I have that's been filed for some time. I know it's amended, and there was a couple of tweaks made to it after my comments from last week, but I'm going to get an order entered today. I agree that I'm not just thrilled with the language in this paragraph, and I agree it could be cleaned up, but I'm going to make it enforceable. We're going to get this order entered this morning. Give me a second, though.
Well, for the court's reference, I have it in my draft on pages 7 and 8.
Okay.
We can copy, paste, stick at the end of, whatever it is. And part of the issue, Your Honor, is I was under the impression this entry was set for Friday, not tomorrow. I mean, not today, so.
Yeah, and tomorrow's Good Friday, so this may have thrown a lot of people off. Okay, I've added some language that I feel makes that paragraph enforceable and addresses the issues. It says a temporary order. If this were a final order, I would be, I mean, I think it's enforceable as it's written, but for the final order, we're going to use the Texas Family Law Practice Manual for the surrender language and the pickup language. But for purposes of the temporary order, I feel like it's sufficient now with the changes I made.
Yes, Your Honor.
Ms. Robdell, the next issue you have.
The child support. The issue is that it specifies that it's a single monthly payment. I'm not sure that that's standard language, and I'm concerned that it doesn't provide for wiggle room with regard to, weekly, bi-weekly, etc., depending on how he gets paid.
Well, Your Honor, there's a withholding paragraph. If she would like to draft a withholding order, it'll take care of that. Judge, again, I didn't receive anything until last night at 8:30. Any changes?
Texas Family Practice Manual was put out by the State Bar of Texas. It is the.
Your Honor, if she would have let me know that a month ago, we could have made some changes, but she didn't let me know anything until 8:30.
I understand. Mr. Foster, I understand that issue, and that's why we're going off your order, and that's why I'm making some changes to the order, because we all want the order to be enforceable. That protects both of y'all and protects both of these parties. And there are legitimate issues, and I know you didn't get them until 8:30 last night, but that doesn't mean I don't want to have an order that I can enforce if somebody starts doing some monkey business and acting out of line. So I know it's frustrating, but we're going to plow through this because it's important to get this order entered. Okay, looking at the order.
The language that I'm proposing is on pages 8 through 10 of my draft.
All right. I'm taking out the shall be paid in a single monthly payment. It's going to
Thank
say
you.
such amount shall be paid on the first of each month. First payment being due and payable on March 1st, 2021, and a like payment being due on the first month each month thereafter until further order of the court. I think that's going to be sufficient now. Through an income withholding order, it'll be taken out of his check, or he can pay those. If someone doesn't get an income withholding order in, he's going to be ordered to pay per paycheck so that it totals $515 per month. But the single monthly payment, I struck through that language because I see how that could be confusing. All right, next issue, Ms. Robdell.
The language, if we could go back, because electronic communication was a thing, but he's got it ahead of where I have it, so we'll track his. The paragraphs on page 6 that provide for independent communication outside of talking parents, even if it's not about the child or an emergency, I think that goes against the rendition of this court.
You're talking about the last paragraph of that
Yes, Your Honor.
section?
Yes.
Yeah, I struck that entire paragraph.
Okay, thank you. Sorry. I don't know that the Texas Family Practice Manual, moving on, defines earnings and disposable earnings as Mr. Foster has in his draft. I'm looking through mine to see if it does. I don't see where it is there. If that's the case, I would ask that that be stricken too.
I read through those provisions when I was looking at the child support, and it appears to be fine to me.
Okay. Then on page 8, I would argue that the two paragraphs, no offset and obligation of the estate, are overbroad compared to the intent of the Texas Family Practice Manual's language.
All right, the no offset one, that request to modify that language is denied. Let me look at the obligation of the estate. That request is denied. Both those paragraphs can stay.
Then there's nothing in the order about health insurance, uninsured medical expenses, etc., that I saw that would be sufficient to instruct the parties with regard to their obligations. And my proposed language is on pages 10 through 18 for health insurance.
Yeah, I don't see that, Mr. Foster. What's like uninsured medical expenses? Is that in this order somewhere?
I'm looking for that, Judge. Yeah, Your Honor, I don't, for some reason, I don't know why health insurance didn't get put in our order, but like I said, I didn't see it, but
I did mention that the last time we had an entry that the order is absent any provisions on health insurance. So if the court would be willing, my proposal then would be to take pages 10 through 18, I think it is, of mine, and append it to Mr. Foster's order if possible, which contains language for if there's secondary coverage, if there is uninsured medical expenses, if someone else wants something different, for following the policies and procedures, etc.
I have father paying cash medical reimbursement in my docket entry of $35 per month beginning March 1st of 2021. Uninsured medical expenses to be split 50-50. The child's on government assistance. Yeah, that's not something I can insert into this order myself. There's just too much.
So we need it.
All right, yeah, I'm looking at Ms. Robdell's order. That language is all good on the 8A. I mean, basically all of 8, medical and dental support, 8, 8A, 8B, 8C, 8D, 8E, 8F, 8H, I, and J, and K. All right, so man, as much as I don't want to do this, it seems like we're starting to get into an order that's going to be a bit of a mess.
Right.
Mr. Foster, health insurance was ordered by the court, and I don't see those. And I understand you didn't get this until 8:30 last night, but I do recall last week she mentioned health insurance being an issue, and it's still not included in your most recent version of the order. So my thought is that it might be easy if Ms. Robdell emails you her order in Word or WordPerfect format, and you cut and paste that section, basically all paragraphs in number 8 into your order so that we've got health insurance in the order. And the problem we run into then, though, is all these changes I've made are not going to be reflected in that order. So,
Your Honor, would your changes be
Go ahead.
changes be visible for us on the county website? If they are, I can have my Maria make changes, your changes, and add this health insurance language.
Or we could just consider my order in its entirety. That was my conundrum. I mentioned last week the format of the Texas Family Practice Manual and my concern that the form of Mr. Foster's order doesn't comport with it, and the lack of insurance information, and the necessity, basically, I had to start over. The changes are so extensive, that's why.
So can I make changes to an order and not sign it and have it as an individual tab? I've never done that, but I'm checking with the clerk to see if I can. I mean, I'm sure I can do it. I mean, the judge, I can make a document that just tells them to do it, but I've never done that before, and I'm not sure. Let me have a second to think. I'm not sure I want to do that. All right, Ms. Robdell, I know you've had issues with the order, and I heard your arguments last week, but I can tell you the court's a little frustrated because I want to enter an order today, and had this stuff been communicated, to Mr. Foster earlier, I think we'd be in a position where we would be able to enter this order today. And I understand your issues that there were a lot of things wrong, and so you just drafted it. But the fact it was filed at 8:30 last night doesn't give me a whole lot of options as a judge to just use your order, because Mr. Foster just got it at 8:30 last night. So I'm a little irritated with this case and how long it's taken to get a temporary order entered. It's not, to me, it just hasn't been handled the way I had hoped it would be handled. And I really am frustrated because I want to get a temporary order in so that I've got an enforceable order. But Mr. Foster, I don't see how I can do that today with a total absence of health insurance information in the proposed order.
Is it possible, Your
So
Honor?
what I'm going to do. Yes.
I'm sorry. First and foremost, I want to apologize to the court. It's not how I like to do things either, for the record, the proverbial record. And secondly, I was wondering, and I don't mean to interrupt, Your Honor, but is it possible perhaps under the circumstances to recess us until this afternoon if Mr. Foster would entertain the notion of considering the order that I have drafted, reading through it? I can send him a Word version. And if it is acceptable to him, we can all be grown-ups about it, maybe, give up control, vice versa. I'd be willing to do the same and either collaborate on one or, adopt another.
Well, the problem I have is Mr. Foster is scheduled to resume a hearing with me, and I've had Ms. McDowell waiting for about 30 minutes from when I told her I was going to start. So that's why you're starting to see me get frustrated, because I don't like being inefficient, and I feel like I'm being inefficient as a judge right now, which is impacting Ms. McDowell's calendar. So we are going to have to reschedule this entry date. We're going to reschedule it for April the 9th. And Mr. Foster, Ms. Robdell, y'all get together before that date, and I may put my order out there on the clerk site. I'll figure that out in a little bit because I'm not positive how I want to do that. But I do want y'all to communicate before April the 9th, and entries rescheduled for April the 9th at 9 a.m. All right, thank you, Ms. Roblo. You're excused.
Thank you, Your Honor.
Thank you, Your Honor.
Before we get back on the record, I'm probably going to take about a 3-minute break just to nuke my coffee and switch gears. But I believe we were on, and I've got to go look at my notes, but I think we were on the direct examination of an adverse witness by Mr. Foster. And so we're going to kind of pick up where we left off. But I remember my issue with this case being that there was requests for interim support and expert fees. And I was concerned that I had testimony about these accounts being separate accounts, and I wasn't sure what the community interest was in those accounts, and if there was sufficient community interest to even do what was being proposed. And so did we make any headway there, or are we still kind of where we were when we left off? And I'll let the lawyers just give me like 30 seconds each, and then we'll take a break and we'll get back on the record. But Ms. McDowell, I know you said you'd already had a tracing expert look at it, and you kind of had an idea, and you were going to proffer that testimony.
Yes, sir.
But I was kind of concerned, really,
And
not your burden, so to speak.
it is not, Judge, and I was not able to secure Ms. Wynn or Ms. Ferguson for today because they're in some other case. However, I was able to get an email from her which showed under the current tracing, because they're double tracing, right? Because of the different alleged dates of marriage. So where Ms. Gallagher alleges February of 2017 and Dr. Simons states September of 2018, they've got to trace both ways, because depending upon, you know, which date of marriage is decided upon or agreed upon, that would determine what the tracing is. So I do have from her, which I have supplied to Mr. and Mr. Foster, the update that I received from her yesterday, which addresses what cash is available, which is not sufficient to meet the requests that they've made. However, my client's prepared and will be giving some testimony about how he thinks it can be done.
Okay. Mr. Foster, I think Mr. Lonnie Foster, you were kind of deep in this case previously. Have you had a chance to review that expert supplemental report or findings?
Actually, our Len reviewed that, and he'll be arguing the
Judge,
motion.
yeah, Judge, yeah, there's no report. There's an email. We just got notice of the person's name yesterday, and we got an email that just gives an amount. No report, no, nothing else to go with it. So we'll certainly be objecting to that email. There's no substantiation to it. We did, since the court wanted some sort of proof that there was not separate money coming out. Mr. Dane Simons, he testified that he was putting $4,500 a month into that account. We have our exhibits, which is the Kercheval account each year with the summary on top that shows all money going in and shows no money going out for those years of the marriage. So, we've got these exhibits. We provided them last time, just the cover page. This time we got the full statements for each month of those years and have summaries that give the totals, but the documents are attached. And I've got about $158,000 put into the account. She's saying cash because the money's put in and it's invested in stock, but it's still community funds going in, and those stocks can be sold at any time. And so that's going to be our position, is that there is more than substantial amount of community funds put into the account. It may not be cash as of today because it's invested.
Well, Your Honor.
Yeah, I don't think I heard testimony yet that there was no expenditures out of the account. So in my brain, I heard that there was testimony of, and again, I haven't looked at my notes yet, but it does sound accurate that it was 4,500 a month. He testified he was
Yes,
putting
and-
in there.
Yes, and you were asking about whether money came out. That's why I have the exhibits that show the accounts and show no money going out. And I have planned to put that on today.
Ms. McDowell.
Yes, sir. If I may, the reason that the importance of whether something is cash or not in the account, what the community may have a claim to in cash, is because that's readily available for withdrawal for the parties at no penalty. There's no question that the community has a claim against my client's various separate accounts. And there, Mr. Foster Lynn is also correct when he says there is no report. No, the tracing's ongoing. We don't have a report because we don't have an end date on our tracing. And that should seem obvious, I would think, but that is why there's an email that shows how much cash there is. And it really doesn't matter. What matters is if the parties decided, if they agreed, because they would have to agree because it's my client's separate property account, they could agree that there would be a specific withdrawal. But as of yet, there's no judicial determination of what the community's claim amount is. So counsel's correct. There was clearly money going in there after February of 2017, which they claim is the date of marriage. And there's some money that continues to go in there after September of 2018, which is when we say they were married legally. And that is not an issue. What is at issue is that when you perform a tracing, there is an amount that inures to the benefit of the community, and that amount determines what the community's claim is. It doesn't matter how much he put in it. He could have put $100,000 a month in it and the market, and it could have lost it all. And there might be zero, in which case there's no claim. So what you have to do is acknowledge intellectually that there is a claim amount. We just don't fully know what it is yet. And that could be, you could get around that by saying, okay, this is going to be the amount that a party or each side is going to take, and we're going to say that is credited towards the community's amount, whatever that might later be determined to be. But legally, they're not going to meet that burden, and I'm trying to help solve the problem. So the only other alternative is we go borrow the money.
So Judge,
Well, and
And you can't force that either.
Well, no, I know. Well, but I'm trying to come up with a solution too, because I recognize.
I am too. I'm not trying to keep the Fosters from having a payment. I'm not making a comment on whether or not they would take a case without getting paid, but at any rate, the point is, if we're going to get the case over with, there's got to be a payment. My client's prepared to put on some testimony about how we think maybe that could be done, but.
and Judge, I don't know if you saw, we passed the motion to compel for today as well, because our plan is to hopefully get money for an expert, get the expert on board so that they can come and then testify exactly what we need in documents, because that seemed to be important to the court. And again, the reason I have these statements is because you wanted to see, is there money going out? I mean, I have the statements ready to introduce. There's money going in. The value is well above what it was when it started, so there was no losses. And as far as the tracing, yeah, it's ongoing, but they could have had a report through December of last year. I mean, this is the first we even finally got the name, was yesterday. And obviously our expert's going to need to see what their expert has so far to review. Well, at least I guess they can wait till 90 days before trial, but the bottom line is we need to get money for attorney's fees. We need money for an expert. And then we still asking for spousal maintenance as well. And I also subpoenaed Mr. Simon's CPA to come here today, since he testified that he had all the 2020 records, but I'm not sure if he's in the holding room or if he's there or not.
Who would that be, Mr. Foster?
Well,
What's his name? Griffith.
Well, after you sent me the email that said you had subpoenaed him, I contacted his office and he said he hadn't heard from anybody and he hadn't received a subpoena. So you might want to check on that.
Yeah, I'll check on that because I was pretty sure he got served, but I'll check on it real quick. You're going to take a break, you said, Judge?
well, yeah, but I also want to want to talk through this just a tiny bit, because what I need is I need this lady to have an expert so that they can, because the problem with the experts is you have several different types of investments. And so it may be that, the money's going in and it's getting put in some certain fund or certain stock. And even though the account may be growing, it may be that that particular stock or that particular sector or fund that the money is invested in was doing poorly. And I'm not going to know any of that until I have experts. And so I need her to have her own expert. And that's something that I'm hoping there's sufficient money to get an expert on board so that the experts can talk, because this is going to be a constantly, every day the tracing changes, because my assumption is this money's going into stocks and going into mutual funds and going into various other investments. And so as the market changes, the community interest is changing in that separate property account. So, but I do think it would be in everybody's best interest that we get an expert on board quickly for the other side, so that the experts can put their heads together, and hopefully y'all can get to a mediation point where you can try to resolve the case. And if not, come in and you try your case to the court. But this case is not going to go anywhere until that process gets started. And so I think it would be good, Mr. Foster, if y'all were to look at what that email says, not saying you agree with it, but if there's sufficient money there to at least retain an expert and get a partial payment on the attorney's fees, to me, that seems like the solution.
No, I've looked at, it's
And then
not,
there's a
it's just a simple, yeah, it's just a simple email with a couple of figures that are so low. And again, it's just talking about the actual cash in the account. And that's because they don't keep cash in that account. All the money is in stocks and stuff. There's not going to be penalties for selling stocks. This isn't that type of an account that I know of. But again, it's money in stocks. And if those stocks have to be sold, if there's some sort of issue with capital gains or something, then that's what happens. But that's where the bulk of the money is in that one account. And it's invested in stocks and stuff. It doesn't mean it can't be sold. It was put in as cash. It can be converted to cash. Her report's only talking about the actual cash in the account, which is minimal because they don't keep cash in there. The report, means nothing to me.
Ms. McDowell, is this an after-tax account, brokerage account, or is it a?
Yes, Your Honor, it is true that this is not an account that typically accumulates a lot of cash. And I believe that Mr. Foster is focused on the Kercheval account. So my client has not only what we call the Kercheval account, but he also has some Edward Jones accounts. They're all being traced. There is not very much cash in the Kercheval account because it is not intended for that purpose. It's a long-term investment account. And Lynn is right that there's going to be an amount from that account that's going to be claimed, if you will, by the community. That's going to be borne out in the tracing. And where everybody seems to be not kind of focused is their separate property accounts. So until there is a proven claim or an agreed claim, nothing can come out of them unless the parties agree to do it. So the other alternative is if my client was able or willing to go borrow money, they could do it that way. We have had some conversations offline, and we are not we've been unable to agree. So I think that
Those are the solutions.
Well,
those are the solutions. And I understand, look, I understand there may be a bunch of money that was deposited into that account, but the facts are it's a separate property account right now as it stands.
Well, in fact,
and she's conceded that.
I've got statements proving, Judge, that community funds were put into that account. Therefore, it's commingled.
No one's arguing that.
Yeah. So this is not just a separate property account just because it was created. Just like if I create a savings account and I have it at marriage and then I add money to it, it doesn't mean everything in there is separate. Everything actually is presumed to be community. And I've got the reports and the statements that are going to show $158,000 gone into that account. You can look at the statements. The account has not gone down. It's always gone up. So there's not going to be an issue of there being not enough community funds in that account to cover you giving us $40,000 and giving Jeannie $40,000.
That is intellectually incorrect. It is a separate
All
property.
right, I'm going to take a,
Inception of title.
hold on. I'm going to take a 5-minute break. Y'all can talk during that 5 minutes. And what I will do is we were going to resume at about 10:35. So y'all are free to talk for the next 5 minutes or so, and I'm going to go. I'll be right back. Get
Thank
started.
you, Judge.
Thank you. I'm going to get Dr. Simons on the phone, Lynn, and then I'm going to
Okay.
get back to you.
Okay. No, no, you're unmuted.
Lynn,
Hey,
can
yeah.
you hear me?
Yeah.
I just want to let you know that I have confirmed that we will still do the 40 and the 40, but you have to, I just want to say this one more time because I think it will make sense to you. We're not saying there won't be an amount that belongs to the community, but we don't know what that amount is until the tracing is done. And the tracing can't be done until we know what the stop date is going to be. Okay. So I understand that there's been money that's deposited, and those are contributions, and ultimately those are going to tick out when they do the tracing towards the community. They're not dollar for dollar because they never are. It might be more than they contributed. It might be slightly less.
Yeah, it just depends on the market.
Exactly. But what I'm saying is when you each take the 40, you're taking the 40 from we're not going to agree that you're taking the 40 from anywhere, because we're not going to agree that we take it from the separate. All we're saying is that 40 and that 40 comes from whatever belongs to the community when that tracing.
Yeah, no, I'm fine. Yeah, no, I'm fine with.
Right. That's what we were saying all along. And Lynn, the reason that we said 40 is because at the time y'all were owed 25. That would give you the 5 or 10 for your expert, and also would give her some money. So that was the whole point of that.
Yeah.
Okay.
Yeah, no, I have no problem with saying that the 40 comes from, that's going to come from the community, whatever it is, when we find that out.
Okay.
You know, so basically,
because when you wrote me back, that didn't say that. It said no to that.
Okay, well, that's not what I was saying no to, but what I was saying no to was you wanted me to drop some of my compel stuff, but we're past that, because I'd like to really, honestly, I'd like to address that today. We need to know when we're going to have when we think we're going to have a trial date, so we know when we have a stop date, so we know when we schedule mediation, if we bother to schedule it again, which I'm in favor of, but I don't care at this point. No, we need to schedule mediation, but we need to get our expert money and have our experts start reviewing. I need her to review everything you've given me, which we're missing a lot of stuff. And then I want her to give me a list of, okay, this is what we still need. I can give it to you. If you agree, great. If not, then we go forward on the motion to compel. I'd like to get all that done, within the next 30 days, and then have a trial date, like you said, either July or I'm thinking maybe later in August, but because the later part of July, Lonnie and I are out. And of course, the first week of August is advanced, so nothing happens. And
Well, I doubt they'll have advance this year.
yeah,
I'd like to try it. I'd like to try it the first part of July. I'd like to seriously get this done. I'd like for both sides to pick a date that we're supplementing through. Each side supplements. If they don't supplement, either one of us gets to go try to compel the other one. You guys have got to get, maybe you should just do it by motion by submission. I mean, I'm not getting in your business, but I'm not going to give you records related to his practice or his patients without a court order because I can't and I won't.
Well, I understand that. And if that's what our expert says we need, then we'll go to the court and get the court to rule on that. But that's what I said. I'd like to get that motion to compel heard if we have to hear it within the next 30 days.
You want to talk to her and figure out if the answer is that they're each going to take 40 and it's going to be a credit against ultimately whatever amount the community is entitled to, whatever that is, whether they agree on that amount or whether we have a trial and the judge or the jury says this is the amount. They have to, they basically have to take it like almost like a partition. They have to take it.
Yeah, no, I have no problem with that. Basically, whatever at the end of the day, whatever the community value comes up to, it's going to be minus $80,000.
That's what I'm saying. But your response to me didn't say that. So that's where we've been off. All right. Now,
okay.
Obviously
That's
our
where, yeah, that's would be the,
obviously our intention was that would kind of be a catch up for y'all. That would give you some money to hire an expert and also gives her some money. So
but that's not going to give her any money by the time we pay attorney's fees. And plus we need, money for the expert. The 40,000, I was fine with attorney's fees and expert fees, but I still want to ask the judge for spousal.
Okay.
And he can do whatever he wants with that. That's fine.
Okay. I'll ask my client about that because to him, it's a package deal, but
Okay. We'll ask him and see.
I'm going to do it right now. Lynn, you have two screens, so I don't know where you are. Cut and paste that language and put it on the screen.
Sorry, Judge.
Oh, you're good. I'm getting my record set up.
Okay. We were actually talking about some of it.
Judge, I have one other.
Yeah,
Yes, sir. I have one other thing that I need to report back to Lynn for their consideration. I'm not going to put.
Why don't I put you on a breakout room?
Okay, thank you.
I do think this would, I encourage y'all to talk because when y'all come to me, my hands are limited. And I think that everybody needs to there's a solution to this. And I just think if y'all talk and put your brains together, y'all can come up with a creative way to get where we need to get going. Mr. Foster, I've got two of you here, so I'm going to send you both there. I'm not sure which one's which. And then you want Lonnie in there as well?
It was seriously $21.
Okay, any progress?
Yes, Judge, we have an agreement for fees and an additional amount that we need to put onto the record. And then we'll do a written order.
Lexi, get on.
Okay, so that takes care of that issue, and we will put that on the record in just a second. I also saw that I had an order to retrieve personal property with some
Yes.
blanks in it.
And I think you're,
Is that an agreement?
I think you need to hear a little bit of argument about that. Is that right, Lynn or Lonnie? Or
Yeah, I was there at the previous hearing, Judge, and I think we've just got some minor issues with that. I mean, I think both parties agree that the parties can go to the other residents on an agreed date. I think there's just an issue about, I think Mr. Simons is wanting some items, specifically a what is it called? A Echo Dot.
Echo Dot.
Which my client is willing to buy him a brand new one. He wants her specific one, which they were both given as a Christmas gift, and it has her account, it has her information, and it has personal information of hers in it. I think that's why he wants it, but she's willing to give him a brand new one.
I think you need to hear some testimony or some argument about that, Judge.
I will. I'll take that on the record. So I was just making sure we didn't have an agreement on that one. And then, so then the only issue that would be remaining is the request for temporary spousal support. Is that correct?
Yes, sir, that's resolved. That's resolved also.
Oh, that's right.
Yes, we resolved
So
that
y'all
also.
aren't going to need
We're going to
The
need
only hearing we're gonna have is-
15 minutes of your time probably on the motion to retrieve and
Okay.
inspect. That would be my guess.
Y'all just made me smile.
Happy
All
Easter.
right, we're going to go ahead and get.
Wait, Judge, that's just an April Fool's. We actually need your full day.
Right. Oh, that's funny.
Yeah.
All right, the court's on the record in cause number 19, DCV 265020. Counsel, if you would please each identify yourselves and the party that you represent for the record.
Lonnie Foster, represent Alexis Gallagher Simon.
Jeannie McDowell for the respondent, Dr. Dane Simons.
And Lynn Foster also for Alexis Gallagher Simons.
And what do we have set? I know we were scheduled for a continuation of a temporary orders hearing dealing with interim support and expert fees. But it's my understanding that the parties have reached an agreement on that, needed to recite it into the record. Who would like to recite that into the record?
I will, Your Honor.
Okay, and let me go ahead and swear. Are you going to ask the parties if that's their understanding of the agreement, or?
I am, and you're going to need to swear him for the rest of it anyway.
Okay. Ma'am, if you would please raise your right hand, and I don't see.
Judge, I think they were already sworn for this hearing, but
I don't think
They were. I'm going to swear them again. Mr. Simmons or Dr. Simmons, if you would please put your video on. for me.
Simons, your video is off. Thank you.
All right, Dr. Simons, raise your right hand for me, please, as best you can. Do each of you solemnly swear or affirm the testimony you're going to give in this call will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. Ms. Gallagher, you may proceed. Ms. McDowell, you may proceed.
Your Honor, from the separate property accounts of Dr. Dane Simons, which the parties are familiar with, there will be an equal withdrawal of a sum that provides $40,000 to Ms. Gallagher Simons and $40,000 to Dr. Dane Simons. In addition, there will be a withdrawal of a sum sufficient to provide $20,000 to Ms. Gallagher Simons, and all of those amounts will constitute a credit against the amount of the community claim / interest in the separate property accounts. So by way of example, if there is $100,000 that the community has a claim against, then at this point, 80 plus 20, each party would take credit for what they have. So Dr. Simons would have to say he got 40 of it, and Ms. Gallagher Simons would have to say she already got 60 of it. So it will be each party acknowledging a receipt of his or her portion of whatever is eventually determined to be community. And that would be after both sides experts, well, that would be after there was an agreement. And if there's no agreement, it would be after a trial when that amount was determined by a judge or a jury. That'll be done as quickly as possible. And I will communicate to the Fosters what I am told may be necessary in terms of tax payments, because I'm certain Dr. Simons will be taxed, which means the community will be taxed at whatever point it comes out, because some of this will have to come from, may have to come from separate.
Okay. If you want to call your client to make sure that's his understanding.
I'll call my client. Dr. Simons, state your name for the record, please.
Wayne Simons.
And Dr. Simons, you've heard what I've just recited into the record?
Yes, I do.
And you agree that you and Ms. Gallagher Simons will each receive $40,000. Is that accurate?
Yes.
And in addition, you have agreed that she may take now or as soon as possible the sum of $20,000 for her own personal expenses or use. Is that correct?
Yes, it is correct.
Okay. And you acknowledge that any amount taken by you and she will be credited against what will eventually belong to the two of you as a community claim.
Yes, I do.
Pass witness.
I have no
Mr.
questions.
Foster,
of
do you
him,
have any
Judge.
questions?
No questions of him.
Ms. McDowell, any witnesses you want to call?
I'll let them call their client, Judge. I think they probably want to.
All right, Mr. Foster, you'd like to call your client for the proof up of this agreement?
Yes, Judge. I call Alexis Gallagher. You please state your name for the court.
You may proceed.
Alexis Gallagher.
Could you hear her, Judge?
Just barely. If she can scoot up a little bit, it'd probably be better, or lean in a little bit.
Alexis Gallagher.
Is that better? Okay. Alexis, you heard the agreement that we've offered to the court for you to get $20,000 and an additional $40,000 to our firm for fees and experts. And you understand that'll come from whatever the community ends up being.
Yes.
Okay. So you understand basically each of you are taking 40,000. So 80,000 of the community is going to be gone, whatever it is, plus another 20 to your side.
Yes.
Okay. And you're agreeable to those terms this time.
Yes.
That's all I have, Judge.
All right, any questions of this witness, Mrs. McDowell?
No, ma'am.
As it relates to
No,
this
sir.
issue. All right, the court will approve those agreements and we'll set entry of this order. Y'all want 4/9 next Friday?
That's
Y'all
fine.
need more time, 4/16?
4/9's fine.
I will set entry for 4/9 at 9 a.m. And let's take care of the any other issues that we have. It's my understanding there's some personal property we need to address.
Yes, Your Honor.
And I know we're continuing this hearing, but we were on, I guess, the Foster's case in chief at that time. So I'm going to let Mr. Foster, I'm going to let you proceed with your argument on this issue first, and then we'll come to Ms. McDowell afterwards. So let me know what your issue is with the personal property.
Judge, if I may, I just wanted to remind the court that we didn't actually go forward on this motion because Mr. Foster had announced agreement. And I think part of the issue seems to be that although that agreement was announced, that's now changed somehow.
Well, Judge, it's not changed. I think the hearing was started, and I think the court saw that we're in agreement for both parties to go view the other residents and get an agreed date. We're just not in agreement with him taking whatever he wants, which I think she has some things in the order that he can take an echo dot and he can take other things, but we're agreeable that both parties can go view the other residents, video it, take notes, whatever they need to do to determine what's there. He can take personal effects, clothing, anything that he's left at the residence. I think a big thing is he wants this Echo Dot, which they were both given as a Christmas present. It has her login, it has her private information, and he wants her Echo Dot. We told him we would buy him a brand new Echo Dot. And that's where we're at.
I recall that he testified there was an Echo Dot, there was like a knife block, there was a couple of things that he testified specifically that he wanted to get out of the house. And I recall the parties agreeing that each side would inspect and go in and get personal belongings out of the house. But if we've got an issue on the Echo Dot, then we're going to take some brief testimony on it. But as you all know, we don't want to spend more than 20 minutes talking about Echo Dots. We could buy 20 Echo Dots with what we're going to cost to litigate that particular issue. But I do think the parties need to, if there's a list of items that he wants, Dr. Simons wants out of the residence, and she's objecting to that, then I need to hear a brief testimony about what it is, so that I can make a decision on it.
It's in our motion, Judge, and that's where it came from. And so I understand we want to do a limited testimony on it, but it came directly from the motion.
All right, let me pull the motion up, but I do recall his testimony about
Yes,
that
sir.
as well.
What I'm saying is he had a request to retrieve specific items, which he testified what those were.
Okay, well, since it's his motion, then we're going to proceed with Ms. McDowell going first on that motion then,
All right.
from a
Come on.
scheduling standpoint. So Ms. McDowell,
Yes,
you
sir.
may call your first witness on it.
Dr. Simons, can you please explain to the court whether or how you came to acquire the Echo Dot?
Given to me as Alexis.
And who gave you that?
Alexis.
And in fact, do you recall on approximately March 10th of 2020, do you recall when your wife gave her deposition?
Yes, I recall.
Okay.
I-
And in her deposition, did she state that she had the Echo Dot?
She did.
And did she also state that it was a gift to him, to you,
Yes, she did.
and that you could have it?
Yes.
And that was approximately a year ago, was it not, sir?
Correct.
Okay. Now, with regard to the Echo Dot holding some kind of information for Alexis, do you agree that any information that she may have put on this Echo Dot can be removed?
You can remove it, yes.
Okay. Last witness.
Mr. Foster?
Yes, Judge. So what if everything's wiped off of it, what's the difference between that specific Echo Dot and a brand new one?
That was given to me as a gift, and it had my information before it had hers. I suspect that's how she's spying on me or watching what I'm doing or listening to what I'm doing.
Objection, Your Honor, non-responsive.
Overruled. I think he answered it.
Okay. So a brand new Echo Dot that has nothing on it would be the same as a wiped out version of the one that she has with her personal information on it.
Objection assumes facts not in evidence.
I'm just asking him if he'd be happy with a brand new one, Judge, instead of one.
I'll allow it. You may answer that question if you remember it.
So the question again, please.
Sorry?
Repeat the question, please.
Are you telling this judge that you want her specific Echo Dot wiped out?
I want my Echo Dot.
You actually got this as a Christmas gift from her. Actually, you and your wife got this as a Christmas gift from her boys, correct?
That's incorrect.
Okay, so if they come in and testify, they gave you and your wife this Echo Dot, they would not be telling the truth.
If they testified that, it would not be accurate.
All right. But you're telling this judge you have to have that specific Echo Dot because it's got her information on it.
Because it's got my information on it.
If it doesn't have your information on it, you don't need it, do you?
It does have my information.
All right, objection, Your Honor, non-responsive. My question was, if
Sustained.
it doesn't have your information on it, you don't need it, do you?
Objection calls for speculation. Objection asked and answered.
Sustained.
We pass witness, Judge.
All right,
Yes,
Dr.
thank you.
Simons, in addition to the Echo Dot, you are missing your passport. Is that correct?
That's correct.
Previously in the case and prior to the time that your wife was represented by the Fosters, do you recall that she represented that your passport was in the safe?
Yes, I did.
And what safe was she referring to, if you know?
The safe that was in a secure room and at my residence.
And during the property inspection and retrieval that your wife performed at your residence, did she open the safe?
She did.
And was your passport there?
No, it wasn't. Nothing was in there.
Did your wife explain or give you any other information about where your passport had gone?
No, she did not.
Okay. Now, and you're requesting that you get your passport back, are you not?
Yes, I am.
Okay. Now, your wife has items or boxes of items that are at your residence in your barn and inside the residence. Is that right?
That's correct.
And during the property inspection, did Ms. Gallagher Simons ask you to hold those or say that those were for her grandchildren?
There's one box of toys that she asked for me to hold for her grandchildren. The rest of it, she said that she didn't want it.
Okay. Do you want her to have the opportunity to retrieve, to pick up whatever items she wants to keep so that you can get rid of whatever is left?
Yes, I'll pick it all up.
Whatever she prefers.
I'd like to be done with it.
Okay.
Been at the house many times to do so, and she doesn't get it.
And then when she was last at the residence with her movers, can you tell the court whether they had the opportunity to take those items?
They did. They had opportunity. They had plenty of manpower and plenty of truck space.
Now, did you tell Ms. Gallagher Simons movers that they needed to leave? Pass the witness.
Just for the record, Dr. Simons, we didn't get your response. Did you tell there's a record that's taking down everything that you say, and sometimes your mic is cutting out. So if you can repeat that answer, did you ask the movers to leave that day?
No, I did not.
Mr. Foster, your witness.
Did you tell the movers not to take her personal property?
No, I did not.
So you didn't tell them that's it, that's all the property, and then they left?
No.
But you're asking the court to destroy Miss Gallagher Simons' personal property if she doesn't come pick it up. That's what's in your motion, right? You're asking the court to destroy her property.
I'm not asking the court to destroy it.
You're asking the court for permission to destroy her personal property.
That which she does not want.
Well, if she wants it. So
Tell me she didn't.
well, okay, we'll ask her about that. But you're asking the court for permission to destroy her personal property, aren't you?
Objection asked and answered.
I don't think he answered it, Judge.
Overruled. I think you did.
You're asking the court for permission to destroy her personal property, aren't you?
Objection asked and answered. Objection argumentative.
Sustained. I meant that I'd already heard the answer to that. Sustained.
What was the answer, Judge? I didn't hear it.
He said he wasn't asking the court to destroy the property. He was saying that if she doesn't want it or she doesn't pick it up, he wants to be able to dispose of it.
Okay, you want to dispose of her personal property?
That which she does not want, yes.
Okay. Well, so if she says she wants it, then we'll just keep everything in place, right?
Objection, argumentative. Objection assumes facts not in evidence. Objection, mischaracterization of the witness's testimony.
Judge, it's cross-examination.
You may answer that, sir.
Yes, question again, please.
If she says that she wants to keep that personal property, then we'll just leave it there until this case is resolved, correct?
I would love for her to come pick it up as soon as possible.
Okay, my question was, if she says she wants it, then we'll agree not to throw it away, correct?
Objection, the witness is being asked to agree. It's a settlement discussion.
Thank you.
I'm sorry, Judge, what was that?
As sustained as to trying to enter into settlement with him.
Okay. But you just want to destroy her property to harass her some more, correct?
That is not.
Objection, argumentative.
All right.
Sustained.
And you want her specific Echo Dot that has her information on it for what reason?
That Echo Dot has my information on it.
Okay. We pass the witness, Judge.
Dr.
Mr.
Simon.
McDowell?
Yes, briefly, Judge. Dr. Simons, the proposed order that was filed has blanks in it, and the blanks were intended to be filled in by both sides' attorneys so that a mutually convenient date would be chosen. That would be not only for your convenience, but also for Ms. Gallagher Simons. And is it still your intention for the attorneys to choose those dates, or are you asking the court to impose a dates?
I would like the court to impose a date. We
And
can
that
agree.
date, and that date would at least serve as a deadline so that if not, was not accomplished by then, that's the day it would occur. Is that right?
Right.
That's all we have, Judge.
Mr. Foster?
Yes, Judge, we'd call Alexis Gallagher.
Well, any questions to this witness?
Oh, no further questions of this, Judge.
All right, Mr. or Dr. Simons, how many boxes are we talking about? Is it 5, 10, 50? Do you have any idea?
30 or 40.
Okay, thank you. Any additional questions after my questions, Ms. McDowell?
Not right now, Your Honor.
Mr. Foster?
Nothing further of this witness, Judge.
All right, Ms. McDowell, you may call your next witness.
I'd call Ms. Gallagher Simons. Ms. Gallagher Simons, can you
You may
tell
proceed.
the court if you recall what the date was when you last appeared at Dr. Simons to retrieve items?
I'm gonna guess November 11.
Okay, and at that time, you had movers with you, is that right?
I'm sorry, could you repeat that?
Yes, ma'am. At that time, did you have movers or people who were serving as movers with you?
Yes.
Okay. Now, are you familiar with the boxes that are in the shed or barn, which are all stacked kind of in a location near a tractor?
The ones that are in the dirt outside, those?
They're the ones that, well, you have an exhibit that has a picture of them. Let me show you.
Oh, that one, yes.
Yeah, that you, on your exhibit, you have a picture and the
Yes.
box, you show somebody. Okay, and so are those boxes yours?
I have no clue what those boxes are. I can assume, but I don't know. Whatever they are, it is trashed.
It's trash?
It's the things that I have gotten back have been damaged. I assume those have been outside in the weather, getting wet, getting hot, and I'm sure they're probably destroyed.
Okay. Well, be that as it may, you are referring to the boxes that are in the shed or barn behind the tractor, right?
The ones that are stored outside, yes.
Yeah, they're stored outside. Well, who stored them outside?
Yes,
Who stored them outside?
my husband.
Okay. And so is it your testimony that you want those boxes?
I don't want things that are wet and moldy. I would like to know there are things I went to pick up in the house that were not made available to me.
Okay, what items are those?
I tell you what would probably be easier.
Excuse me, objection.
Oh,
non-
I'm sorry, what would be,
Objection non-responsive.
I didn't hear her answer. You said a what would be better?
I believe she said, I'll
And
tell
what
you
was
what
your-
would be easier.
Oh, okay, sustained.
Okay, Ms. Simons, is there a time frame that would work for you? Would there be a day in the future, like, by which time you could make arrangements to go get your things or inspect them? And if you did not want to take them, then you would leave them there and Mr. Simons could dispose of them. If so, what date would work for you?
For me, there would need to be a contingency.
All right, so there's not a date that works for you?
I would like to know what my husband has there of mine and what he will make available for me to pick up. And if he can do that and tell me he will make those things available for me to pick up, then we can get that done.
Okay, tell the court the number of times that you've been to the home and the property to retrieve things.
Twice.
Okay, that's officially through the lawyers, correct, ma'am?
I'm sorry, what did you say?
That's 2 times that were agreed upon by the attorney, by your first attorney, Mr. Brown, and then separately by Mr. and Mr. Foster, correct?
Thank you. Yes, correct.
Okay, and that does not include the times that you were at the residence and removed things yourself, correct?
I didn't go back there after I filed for divorce. So what are you talking about?
Well,
I don't know what you're talking about.
okay, all right, that's fine. So when you were at the residence the last time, did you have the opportunity, and I think you know that the entire inspection was recorded, right? You know that.
No, I didn't know that.
Okay, well, I'm going to make sure that you know that. The entire inspection was recorded. So tell the court whether you had the opportunity to go into the home and go through the home and look for items.
Yes.
And tell the court whether you had the opportunity to go outside through the sheds or whatever that you call that thing where the boxes are and look at items. And you had the opportunity to take.
Yes.
Okay.
I'm
So
sorry.
that's okay. So at that time, you had boxes that, although you don't know what's in them, they are still at Dr. Simon's home. Is that right?
Yes.
Okay. Do you want to get those items?
As I explained, I went up there and the movers were there. I set out everything I could. I set out everything that I could that was on my list of things that were not made available to me. And I told my husband before I left that if there's any room left for anything else, will you please ask the movers to load it? And he said, yes. So I said, thank you very much. I appreciated it. And when the movers got to my house, they said that was everything. And my husband told them there was no more to load. The movers had plenty of room to load.
Okay. Objection non-responsive at this point. Ma'am, let me ask you a question. Are you trying to tell this court that in view of all of the many issues between you and your husband, Dr. Simons, that you asked him to be in charge of what went in your trailer when you moved it?
Yes, after I left, because there's no reason for me to stand around. And my husband wanted to get rid of this stuff, so he says. But apparently, once I left, he had the movers go.
Okay, Miss Simons, Miss Gallagher Simons,
It's all right, I don't care.
you do recall this is just a reminder, the entire inspection was recorded. Who left first, you or your movers?
Sorry,
Who,
what did you say?
who left the property first? You
I did.
or your movers? Yes.
Mhm.
Okay, so if you,
So if it was recorded,
ma'am,
if
that's,
you,
that's my
if you
question.
recorded me,
Objection non-responsive. That's the end of the question.
Sustained.
oh, we were outside.
Ma'am, is there a date that works for you by which time you can retrieve your items from the residence?
Objection, Your Honor. It's already been asked.
It was asked, and she said there was contingency, so I'm not real clear on what her answer is. So I'm going to allow the question just so I get some clarification on what her position is. Yeah, objections overruled. Yes, she's asking if there's a date by which you would retrieve these items that you want.
If my husband can provide the items that he is going to allow me to have, if he would provide me a list of what I can pick up, I'd be happy to schedule. But I don't want to go up there a third time and not be able to get the particular items I was looking for. It's just a game and it's not worth.
Well, ma'am, if it is a game, what part of the game are you playing? If it's a
What
game,
did you say? What?
if, as you say, it is a game, what part of the game are you playing?
Exactly. I'm not playing the game. So if he wants to provide it, provide me what I can pick up. And if he doesn't, I mean, there's no reason for me to go up there again because he's not making things available.
Right. Objection non-responsive. What specifically do you mean when you say provide it? For example, allowing you to enter the home and go through and look for things, is that providing?
No, not completely.
Okay. What would be, in your mind, what would he have to do to provide?
Well, he'll just move them again, but there's a room outside of the house where he put my wine glasses, and he did that right away. I've got all my ski clothes. I've got 2 pairs of Luke Casey boots. The list goes on. They
Okay.
aren't there. I asked him where they were.
Are you saying there's a room where that you need to look in? Is that what you're saying?
Yes, I asked to look in it. And since you recorded the whole thing, you heard me ask for that to open it. He said, no, there's a combination. I said, what's the combination? I don't know the combination. Who knows the combination? I don't know. So since you recorded the whole thing, you know this.
Objection argumentative, ma'am. Do you think it's a joke?
It's the truth.
Do you think it's a joke?
I think it's the
Objection, Your Honor.
truth.
That's being argumentative.
Pass the witness.
Sustained. Mr. Foster, your witness.
Thank you, Your Honor. Alexis, is there a reason that you would still like, if he wants to come out and review your residence, are you okay with that?
Yes.
But do you want him just going through anything he wants to? Or
No.
what do you want to ask the court to limit that to?
I'd like to know what it is that he wants.
Okay, well, in his motion, he's asking for an echo dot, correct?
Yes.
And where did that echo dot come from?
So the story behind the Echo Dot is I wanted one. My husband told me I couldn't have one. So I bought one and I called my kids and I said, you're giving us an Echo Dot for Christmas. I bought it, I wrapped it, I addressed it, I opened it up, I put it on my account, and I used it at the house. And that's one reason why I didn't want to leave it there.
Okay, and so did Mr. Simons, did he put any information in that echo dot?
Not to my knowledge.
Okay, are you willing to buy Mr. Simons an echo dot, a brand new one?
Yes, then it will be much better.
Okay. Also, he's asking for a knife block.
That is mine. And that was a gift to me from my husband for Christmas.
Okay, so probably something that needs to be on final settlement.
Yes.
Okay, if they're, all right. His passport, do you have his passport?
No.
Do you know where his passport is?
He used to keep it in the little safe in his closet.
Okay, but to your knowledge, you don't know where it is,
No, I absolutely do not know where it is.
but you would be willing to give it to him if you find it.
If I run across it, I will absolutely give that to him.
All right, and after, and then are you agreeable that both sides get an agreed date where they can go view these areas that they believe they need to look at?
With my husband coming to view mine, yes.
And what about you going to view that locked area?
He'll just move it again. There's no reason.
But
Objection.
you're asking the court,
Responsive.
are you asking the court for permission to go try and view that locked area? If,
If I decide that there's things there that he gives me a list that I can have.
would you like to provide a list to them of things that you know are there that you would like to get back? Personal items.
Objection calls for speculation. I think the witness said she didn't go in a room. She wants.
Yes, more.
Overruled.
Sorry.
You may answer, ma'am.
Okay, I'm confused.
Do you think you could make a list of items that you know were there that you would like to retrieve?
I could make that list. I provided it previously. I would like for him to give me a list of, if I show up, a list of what he has and that I can pick up. That way, if he's not going to make it available to me, then there's no reason for me to go up there a third time.
Okay. And as far as the movers, what happened on that day?
We were there moving and we were out near the garage, and I was putting like the major things that were on my list I was looking for and setting aside for the movers. And we were outside the barn, and I put everything out, and I just said, hey, I've got everything out. If there's room for anything else, we ask the movers, we point to it and direct the movers just to load everything they can. And he said, yes, that he would. My husband said, yes, I'll do that. And I said, thanks a lot, because I figured he would want it gone, but apparently not.
When the movers arrived, was the truck full?
No.
How full was it?
I would say when I left, it was only about a quarter full.
Okay, so there was plenty of room for other things.
Lots of things.
And were those items that your husband said he would tell them to put in there, were they put in the truck?
No.
But any items that you believe are still there, that are in good condition, you would still like to retrieve those?
Yes, if my husband can acknowledge that they're there, and anything else, if he will acknowledge that, yes, and in writing, yes, I have these things, Alexis, you can come pick this up in writing. But I don't want to go up there a third time and I go, where's this? I don't know. Where's this? I don't know. Where's that? You can get your kids' toys. Well, okay, that's fine. But let's get my priorities in the van or in the truck first. So.
All right. Do you know if any of your items were destroyed so far or damaged?
Yes, I did have damaged property.
Okay. And where were those items located?
In the house.
In the house? How were they damaged?
Well, I had a lamp broken, a bedpost broken. I did supply lots of pictures of all the clothes I got back. I guess he stored them in the barn and then brought them back in the house, but I supplied y'all with the pictures. I mean, just everything is ruined.
And were those items damaged or ruined before you left?
No. He had them in garbage bags. So I assume they were out in the barn with all the other stuff because there's just no way it could be like that.
Objection assumes facts not in evidence, objection, speculation, objection, non-responsive.
Sustained.
Okay,
Alright.
in trash
The
bags
last
for
part.
sure.
Okay. Way past the witness, Judge.
I don't have
Ms.
any other,
McDowell?
I don't have any other questions for her, Judge.
All right, Ms. McDowell, any other witnesses you'd like to call on your motion?
Yes, sir, I need a brief recall on Dr. Simons rebuttal.
Okay.
Dr. Simons, you provided personal items that belonged to your wife, clothing, shoes, purses, whatever that stuff was once before. Is that correct?
Yes, I did.
You've heard your wife's testimony that she believes that you stored those outdoors. Is that correct?
Yes.
And with regard to the items that are still at your home, isn't it true that there are items that belong to her and or her adult children inside your home? Is that correct?
Yes, sir.
And are there also other items, whatever they are, that are in her boxes, which her picture shows are behind that tractor in the shed?
Correct.
If it rains, is it possible for those to get wet?
No.
Okay. And that's because it's under the roof of the shed. Is that right? And anyone would be able to see that if they looked at it or just looked at her picture, correct? Did your wife leave before her movers or after?
He left before the movie.
That's all we have, Judge.
Just briefly, Judge,
Mr. Foster?
Barn doesn't have sidewalk.
how were her items damaged then if you say they were protected?
Objection calls for speculation.
If he knows.
Judge, if he knows that they were damaged, I can ask him, I think, cross-examination.
Yes, but he didn't say they
You
were.
can ask if he knows how they were done.
Do you know her items have been damaged?
No, I don't.
You haven't seen those pictures we sent to you?
I've not seen any pictures of damage.
So if her items were damaged, you don't have any idea how they were damaged.
No, I don't.
That's witness, Judge.
That's all we have, Judge.
All right, Mr. Foster, any witnesses you want to call on this motion?
No, Your Honor.
All right.
Judge, I have a brief argument statement if the court's inclined to hear it.
Yeah, I'll give each of you just a few minutes to give me closings. Ms. McDowell, you may proceed.
With regard to the Echo Dot item that Dr. Simons has requested be returned to him, it is his testimony that he had his personal information stored on the Echo Dot. So whether the Echo Dot is to be awarded to him or not, if the court said, well, I don't know whose dot it is, we're going to let that happen during trial. We're going to figure that out later. Our request, Judge, is that his information not be accessible to Ms. Gallagher Simons in her home. We have concerns, pretty significant concerns about use of that information, and that's by virtue of her own testimony. So with regard to the Echo Dot, if it's not going to be returned to Dr. Simons, it's going to need to be forensically wiped so that she's not able to use his information. With regard to the proposed.
Anything further, Ms. McDowell?
Yes, with regard to the proposed order, Judge, I think that the Fosters in my office can come up with our own dates, but there's a blank in there if the court wants to give us a deadline by which time we should do that. And that's all we have.
All right, thank you. Mr. Foster?
Yes, Your Honor. As far as this Echo Dot, our client would be agreeable to just destroying this Echo Dot. That way, no one's information can be found on it. Completely destroy it. And as I know we can come up with some agreed dates where both parties can go view other premises to see if any other items are there. I think the passport, our client has no idea where it is. So if she finds it, she will be agreeable to return it. And I think the other item they asked for is a question about whose item it is. So, Your Honor, we're just asking the court to either allow Ms. Gallagher to retain the Echo Dot because it's on her account that's on it. I believe only one account can be on an Echo Dot. But if the court has an issue with who would get that particular Echo Dot, I say have it ordered destroyed.
Your Honor, we're opposed to the destruction of evidence and are going to ask for a spoliation instruction at this point.
Well, then we'd ask that Ms. Gallagher keep the Echo Dot, then she'll buy him a new Echo Dot.
That's not the issue, Judge.
Right. I heard the arguments. All right. So here's the court's ruling. Some of this stuff seems pretty basic, and but we just have to have hearings sometimes to get this stuff done, and I understand why. But Ms. Gallagher, if you have items at the ranch, it just makes sense to collect them at some point and get them out of his house. I don't think it's right for us to have 30 or 40 boxes in someone else's home. Just like if your husband had 30 or 40 boxes in your home, I'd be doing just the opposite ruling of what I'm doing as far as these boxes. And I'd be having him come pick them up because it may be that the property's damaged. And if it is, that needs to be documented, evidenced, photographs taken, and that can be presented to a court at a later date. But it's not doing the court any good or you any good to just keep it at his house. So the 30 or 40 boxes, they're at the ranch. I'm going to give a deadline by which wife is to pick those up. After you've had an opportunity, Ms. Gallagher, to go through those boxes and sort through what's damaged and what's not damaged. If you're still missing items like the 2 Lucchese pair of boots and the stuff that you're testifying that you think is still there, if that's not in these 30 or 40 boxes, then you can make a list of items that are missing, get with your lawyers, and we can come back in and we can fight that fight a different day. But those items that you're wanting may actually be in good shape and in a box, and I want to get those to you because that just makes sense to me. As far as the knife block, I have conflicting testimony as to what the characterization is on that, and I'm not real sure. I think that's something that I'm going to need to resolve on final. So I'm not, the knife block is going to stay in wife's residence for now, and we'll fight that fight a different day. On the passport, I am going to allow husband an opportunity to go in and look for the passport. Each party is allowed to have a witness with them. Each party is allowed to record this. But husband needs his passport. And so wife, I want you to look for it and see if you can't find it. If you can, then there's no reason for him to be going through the house and looking in safes and stuff at the house because the items that he wants have been provided to him. But if you can't locate his passport by the time the inspection comes forward, then he's going to be allowed to go through the home looking for his passport, and each side will be allowed to have a witness there. But we need to find this gentleman's passport if we can. As it relates to the Echo Dot, my view on this is husband says it's his separate property. Wife says that she bought it herself. But either way, it appears to me like it needs to be in husband's possession. And at least for now, if it's community and that's in fact the way it goes down, well, maybe I'll award the Echo Dot to wife in a property division. But right now, there's at least an allegation that husband's separate. It was a gift. And so the Echo Dot, husband's going to be allowed to retrieve his Echo or the Echo Dot that he claims was a gift to him. Wife is allowed to remove her personal information from the Echo Dot before husband picks it up, but you're not to delete any of his stuff. So if you need to unlink it from your account or whatever you need to do, you're going to be authorized to do that, but you're not to take any of his information off of that Echo Dot. And that's the ruling on the Echo Dot. So husband will be allowed to retrieve the Echo Dot and and search for his passport in the event it's not located before the inspection date. Now, as far as the inspection date, lawyers, I'm going to let y'all do that, but I will give you my position on it. 30 or 40 boxes, my thought is, that's quite a bit of stuff. And that's inconvenient to have someone storing that in their house for a long period of time. So I would think within 45 days that those items need to be removed. And I think, within 45 days, husband should be allowed to go through and get his Echo Dot and a search for his passport. But I will let y'all figure out an exact date so that y'all can get an enforceable order, and y'all can add in there that both parties, when they're doing these retrievals, are allowed to video, and both parties are allowed to have one independent witness there if they'd like. Okay. Anything further that failed to address from either side that you think needs to be addressed?
Your Honor, we had a request, which really was as part of their compel that they are not going to be going forward on today, that related to end of discovery, trial, and mediation. I do not mind offline sending my proposals to Mr. and Mr. Foster and letting them look at those in hopes that we can agree on something, and if not, do we need to file a separate motion for setting?
Yeah, if the parties can agree on a trial date and a mediation date, then you can just file a motion to set those, and I will do that. Of course, a lot of that's going to depend on, let's get an expert for the Fosters. They are going to select an expert, and then that expert's going to need some time to get their report done, and then we'll set our deadlines based on that. So the expert's kind of a factor for me in setting that, and they're going to need time to designate and get all that stuff done. But
Yes, sir.
now y'all can agree if
Yes, sir.
everybody's wanting to get this case done quickly, y'all can agree to alter those designations as y'all know.
Well, I
But
recognize
if I'm
that-
the one setting it, then I'm going to take that into account. So, but yeah, you need to file a separate motion if y'all can agree.
Okay, I'll do that. I recognize they're going to have to get the money in hand before they can look at that.
All right, thank y'all. That completes the court's ruling. We're going off the record. Y'all have a good weekend. Good Easter.
All right. You too, Judge.
Thank you, Judge.
Yeah.